Hi, I'm attorney Tyler Moffitt, and today I'm answering questions about DUI stops and what we look for as we take over a DUI case and investigate it and defend it. Okay, so typically a DUI case or investigation starts with a traffic offense. Most of the time, officers will get behind someone and follow them for a little while and watch how they drive, right? So they're looking for, are they failing to maintain their lane? Are they speeding? Are they weaving in and out? Are they following someone too closely? All these kind of, they're going to say manifestations of someone who's impaired, right? At that point, at some point, they're going to pull them over. Once they pull them over, they're going to start their process for investigating what they believe may be a DUI. And in this, they're going to look for manifestations of impairment. So the common one they say is, hey, we saw bloodshot eyes, right? That the eyes were watery and had red in them, which to them is an indication of impairment. And they're going to say, in 99% of the cases of a DUI, they're going to say, we smelled alcohol, right? And that just goes to the officer's credibility. Most of the time, officers are not wearing a body camera, so we don't get to see these interactions, and we don't get to see the eyes. We don't get to see if they were bloodshot. And we don't get to, there's not an independent test that says someone smelled like alcohol, right? But we can cross-examine an officer to see exactly what that smell was, right? Just because you smell like alcohol, allegedly, doesn't mean you were impaired, right? It can mean anything. It can mean someone poured a drink on you. It can mean you went to a bar and it smelled like that. And also, like, what does alcohol smell like, right? Different things smell like different things. So a lot of room for cross-examination right there to discredit the officer and to try to make the case weaker. But in this initial stop, this initial interaction, they're going to look for those manifestations, right? Bloodshot eyes, watery eyes, smell of alcohol. They're going to look at your speech patterns. Is it slow? Is it slurred? And unfortunately, that's all subjective, and someone may talk regularly in a slow manner or a slurred manner. It doesn't mean they're impaired, right? But they're going to look for those manifestations. At some point, if they see those, if they recognize those, then they're going to ask you to get out of the car. And at that point, they're going to start their another process where they're looking for how you walk. Are you unsteady on your feet? Are you moving slowly? Are you losing your balance? Are you having to brace yourself up against somebody, up against something? And they're going to bring you in front of their car because they should have a dashboard camera at that point. So they're going to get all this on tape. And from there, they're going to interact with you some more. They're going to ask you questions. Where are you going? What were you doing? And then at some point, they're going to ask this question. How much have you had to drink tonight? This question is killer in these cases because what they're doing is they're setting you up to say, have you had anything to drink? And when you respond with, I've had 2 or 3 drinks, now they've got you locked into a statement where you've admitted to having something to drink. So you have every right to refuse that question. You don't have to answer that question. And in fact, I would encourage you not to, because anything you say will be used against you. Even at this point, they're looking to build a case against you. So if you admit to having a drink or 2 drinks, that's going to be used against you later on, right? From there, they're going to start doing standard field sobriety test. There are 3 that are recognized in the state of Georgia and the United States as scientific certainties. There's the HGM test, where they're going to place an object in front of you and have you track it with your eyes to see if there's a nystagmus in your eyes. Okay? It's an objective test, and you, the one doing the test, won't know if you pass or fail because you can't see your eyes and see if there's an involuntary jerking in your eyes. But the officer will be looking for that. They're looking for certain clues in that. So they're going to make several passes, and then they should go up and down, vertical as well. Then they'll do either the walk and turn or the one-leg stand. They're going to give you certain instructions, and all along while they're doing this, while they're giving instructions and while they examine you, they're looking for certain clues, right? On the walk and turn, do you follow the directions, right? So they're going to tell you to go ahead and get in a certain stance. And while they're giving you the instructions, they're going to watch to see if you're struggling to follow their instructions, if you're falling over, if you're losing your balance. And then they're going to have you take 9 steps, heel to toe, turn around, and do 9 steps back, heel to toe. And so all the while they're watching you. Are you unsteady? Are you losing your balance? Are you using your hands to help you walk? Are you missing your heel to toe? Do you do the correct amount of steps? Do you turn around correctly? All these things are clues for them. And then they're going to have you do the one leg stand, where you're going to stand on one foot, lift your other leg, hold it until they tell you to stop. And all the while they're looking, do you put your other foot down? Are you unsteady? Are you losing your balance? Are you, again, using your arms to help you maintain your balance? All these kind of things, right? So all these variables, they're looking for certain clues, and those are the 3 important tests they're going to use to determine whether or not you're DUI and whether or not they're going to charge you with DUI. Again, you have every right to refuse those tests. The officer's not going to tell you that, though. They're not going to tell you that you can refuse that test and that you don't have to take it. They're just going to tell you, are you going to do this? They're going to suggest that you need to do this. And they're going to expect you to do it. If you refuse that test, well, that gives them a weaker case, right? Those are the certain tests they have to use, they don't have to, that they try to use to strengthen their case, because those are the only recognized tests in the state of Georgia, in the United States, that can lead them to a scientific certainty that you're under the influence of something, right? So they're not going to tell you that you can refuse it, but you certainly can. We advise our clients to refuse those tests, right? That makes their case weaker. So in this interaction so far, they've had interaction with you, they've talked to you, they've seen your manifestations, your eyes, your speech, smell, and now they've asked you to how much you've had to drink, and they've done the standard field sobriety test. At some point, they may want you to blow on a roadside breath test. It's called the portable breath test or PBT test. And they're looking for anything in your system which would render proof that you have alcohol in your system, right? So not, at this point, it's not were you above the legal limit, it's was there anything in your breath indicating presence of alcohol. This test is not scientifically reliable enough for that number to come in against you, right? So in this test, you may blow and it may be 0.09, which is above the legal limit, but that test can't be used against you to show you were above the legal limit. The only thing that can come in from that test is that you tested positive for alcohol. So again, you have every right to refuse that test, and they're not going to tell you that you can refuse that test. Typically what they say when you start refusing things are, well, we're just going to arrest you. And they may arrest you. More than likely, if you've gotten this far down this road, they're going to arrest you anyway, whether you take the test or you refuse. So why would you make their case any stronger for, right? After they do the roadside test, they're probably going to arrest you. At that point, they're going to read from a card. They're going to read it word for word. It's called the implied consent notice. Basically, in the state of Georgia, by having a license and having the privilege to drive, you agree that if you are stopped for a DUI, that you will submit to alcohol testing, either by breath, blood, or urine. Okay? And so they're going to read from this implied consent notice. They're going to say that your privilege to drive in the state of Georgia is based on this condition that if you're investigated and asked to submit to a test, that you will. And in this notice, it's going to tell you that if you refuse to do this, then your license will automatically be suspended. Your driving privileges in the state of Georgia will automatically be suspended. Okay? So they're going to read from that notice. They should read it word for word and then ask you to submit to either one of those 3 tests. And then if you refuse, they will suspend your license. If you accept it, then they're either going to take you to the hospital or somewhere to get your blood drawn, or take you to the jail to blow in another machine where that number can be used against you. And they're looking for obviously 0.08 or higher, which would be DUI per se, as the legal limit is 0.08. If you refuse that, well, then they can't charge you with that, right? Because they have no proof that you were above the legal limit. The only other option they have is DUI less safe, where they have to prove that you were impaired and it made you a less safe driver than if you had had nothing in your system. And so if you've refused all their tests, if you refuse to answer the question of whether or not you've had anything to drink, well, they're going to have a hard time proving that, right? It just comes down to the traffic offense and the officer's word that you were impaired based on his training and experience. So we advise refuse these tests, don't take the test. We advise to refuse the implied consent. Now that there comes problems with that, right? At that point, the officer can submit a 1205 form, which would suspend your license. And you have to take it upon yourself to appeal that suspension. You would have 30 days from the date of arrest, the date of being notified of the suspension, to appeal that. And then you go to an administrative hearing concerning your license. And there's things we can talk about to help you fight the automatic license suspension, the administrative license suspension. But if you refuse that test, then your license will automatically be suspended as a matter of law once the officer submits that, and then you'll have to appeal that and have a hearing in front of an administrative judge based on whether or not you refused it. But there's other things we can do to help you protect your license, or instead of having a hearing, you can file the appeal and get a ignition interlock device in your car, and that would be a workaround to the administrative license suspension. With that, this has to be your first DUI arrest and refusal, and you only get a limited work permit, right, to allow you to drive to the doctor, school, work, and you have to blow into it in a machine before the car will start to prove that you're not under the influence of anything. So all those things we're looking for in defending a DUI stop, right? We're looking at the stop itself. Was it justified? What was the traffic offense? What were the manifestations the officer says he saw or smelled? Was there any admission to drinking? Were any of the tests done? Was a refusal? If not, what were the results of those tests? And as we investigate that, we prepare defenses and defend the DUI case.